to Dr. Cassell, if anybody in the audience is interested.
And especially if there are any corrections.
Exactly. Yes, Victor.
I have a, from the, it sounds like from the panel, it is like the, and a trend I see also in just dealing with cases that a lot of these regimes are using the criminal prosecution angle to obscure their political persecution. And that is obviously done, as you noted, with the judiciary branches and, and prosecutors involved. My question is, as you said, Doctor, it's a process of interior recuperation that you have to wait as the change occurs and the judiciary branches come back to effect. But unfortunately, in the meantime, there are a lot of victims out there. Many victims sometimes will end up over here who I've had to work with over here, with red notices, with conviction records, and then lo and behold, you have FBI, you got Homeland Security, everybody investigating them as criminals, and you have to explain, from piecemeal, case by case, hey, this isn't what it appears to be. My question is, internally, like in a country like the United States, being that we're here, what is your view of how do we address that aspect where some of these clearly biased, controlled judiciaries are emitting all these orders that international organizations and countries like the U.S. are giving some credibility to, that causes further, it's a shame the persecution occurs in your country, and then you're fleeing persecution, only to get whacked again by the local authorities enforcing that same persecution. What's the tactic there to try to address that situation in the U.S., in Western Europe, and other countries that are seeing this? What is out there, aside from individually fighting each case?
Thank you, Victor.
Well, that's a question from an excellent and highly qualified jurist. I know that because Victor Cerda was my student who graduated 21 years ago from DePaul Law School, where I was teaching at the time. Obviously, you had excellent teachers, Victor. But not excellent enough to give you a satisfactory answer to your question. As was explained by my colleagues here on the panel, the use of the judiciary to cloak and disguise repression is, of course, a very clever and attractive technique because it hides repression in the confusion of foreign audiences who are not familiar with the legal procedures in a country, do not know whether the judges there are independent, obviously have not had time to review the expediente in order to examine the evidence. And so from a distance, many people at best can say, well, I don't really know. Maybe this guy's actually corrupt or he's a criminal or not. How can a foreign person know? So in that context, I think there are a number of answers to your question. One is to do exactly the sort of thing which the Inter-American Institute and the Inter-American Bar Association are doing here today and through this report and through the further work on these reports, and that is to try to shed light on the specifics of the cases and to penetrate the confusion and to tell the truth about what's really going on and to try to disseminate that as broadly as possible in countries like the US and Europe, if we can still call Europe a country after Brexit. Secondly, of course, in cases where a person has been convicted by a court in, let us say, Ecuador in one of these unjust prosecutions, the only way for that person to be brought back, of course, is through extradition. The proceedings in every country, not just this one, for extradition have provisions in them that someone will not be extradited unless there is sufficient good evidence of their guilt. And the very fact that they have been convicted by a foreign tribunal does not necessarily mean that that evidence existed. So resisting extradition is important. It's a little difficult in this country because the procedures of the Justice Department regarding extradition are very private and internal. I've had at least one case where I had sort of half of due process. That is to say, I wrote a letter to the Justice Department after speaking with the Justice Department lawyers on the case, who told me they couldn't even acknowledge that there was a request for extradition. And I sent them a whole legal brief explaining why the criminal conviction of my Venezuelan client was not worth the paper it was written on. I never got a reply, but they did not extradite my client. So there is that sort of, you can speak to them, but you won't know what the reply is except by their action. And then in the case of civil judgments, because the civil proceedings are also used to create confusion, foreign judgments in the United States at least, and I think the same is pretty much true in the European Union, need to be domesticated in order to be enforced, and there are various conditions for domestication. Among those are that the judgment cannot be based on fraud or gross violations of due process. So there are ways to deal with this in a technical, legal way, but nonetheless, none of them really get at the fundamental problem that someone has been labeled as a criminal. In these foreign proceedings, you generally can't presume, you can't prove that your client is innocent. And so there's this cloud of suspicion that can be damaging to a person's professional reputation, personal reputation, and business interests that's very hard to get rid of. One final response is of course to go to the international bodies. In the 1990s, I represented the former boss of Beatriz Rangel, Reinaldo Figueiredo, the former Minister of the Presidency and Foreign Minister of Venezuela, who had been falsely accused and convicted by the Venezuelan Supreme Court of so-called corruption for his role in sending Venezuelan police bodyguards to protect Violeta Chamorro in Nicaragua after she won the election in 1990, and all the Nicaraguan security forces were still in the hands of the Sandinistas. And as a result of that conviction by the Supreme Court of Venezuela, Reinaldo's reputation was, people thought he was corrupt. He could not get a job anywhere, but we took the case to the Inter-American Commission where we won it. And I think within days after we won the case before the Inter-American Commission, Reinaldo was able to secure very significant positions in the United Nations. So the international proceedings, if you win them, may not necessarily change the result domestically, as Bjorn pointed out, because there may be no way to enforce it. But you can help to regain the person's reputation, which then can give the person new opportunities. I apologize for a long answer, but your question was so brilliant, Victor, that it deserved that response.
Thank you so much. We have, yeah, please.
Thank you. Sonia Schott with Diario Las Américas. Seems to be that the use of the judiciary to favor the political agenda is a trend in Latin America. How do you explain that? Why is it so easy for the government to use the judiciary in its favor? Thank you.
Well, there's good news and there's bad news. The good news is that forced disappearances, massacres, and executions have gone out of style in most of Latin America. We should celebrate that. That's a tremendous advance. If we only think back to the way things were 30 years ago, it was a terrible situation. Now we have most governments in the Americas with various forms of at least the superficial elements of democracy. And if you are a superficial democracy, it's not good for your public relations to go around massacring or disappearing large numbers of people. And so if you want to maintain control effectively, how do you repress and defeat those who criticize you or who are the political opposition? And as has been very well explained by Beatriz and Bjorn in their excellent presentations, using the judiciary, especially if it lacks independence and is controlled, it is an excellent way of repressing while appearing to maintain a facade of democracy. So I think that that's the principal answer, that we now have a new kind of government for whom it is far more convenient to use the courts to create a veneer of legality for repression.
Yes, Bjorn wants to elaborate on this, please. Yes.
Well, no, historically already had all sorts of structural difficulties in building institutions, really strong institutions that fulfill their respective functions. And when the democratic movements started, the real progress of liberalizing and fostering democracy in the 1990s, the judiciary was always the third priority of the governments. It was, the matter of strengthening the government and the parliamentary systems, and I think that many reforms took place over those years. However, the judiciary, well, it was a very expansive endeavor, and maybe not as attractive from the point of view of the publicity in the reform of the structures of the government. So when then, at the end of the 1990s, start of the 2000s, the new populist movements came to power and took over power, they were still faced with judiciaries in transition. And it was easy for them to take over the judiciaries, strip them of their finances, strip them of the people that were working in them, and put their own people and start really using the judiciary as a repression apparatus, following, and that's my guess only, but following maybe some of the examples used by the former Soviet Union and some of the countries in that area that very systematically, and they use this almost like a way of being in the state, trying to use the judiciary to consolidate the power there. So maybe that helps.
Thank you so much. Concerning this preoccupation of many Latin Americans of why is it so easy for governments to take over the judicial system and use it to violate human rights, I think we need to understand that we have a tradition, an institutional tradition that leads us to behave like that. I think Latin America was formed by institutions that were created by Spain, particularly by the sovereign of Spain. This case was Philip II, who was interested in extracting rent from these territories, not creating wealth. There is a big difference between creating wealth and extracting rent. If you want to extract rent, you want to control and suppress every single right, because you need just a very small group of people to be able to extract the riches and take it somewhere else. And the more you exploit the local population, the better off you are. So the institutions are built for that purpose. This is why our economies have been mercantilist throughout our history, and our institutional framework has been corporativist. Now, it is with the emergence of the middle classes in Latin America, which is a phenomenon of the early and mid-20th century, that this has begun to change. And this is why it's so important, the role that can play people like Dr. Arp or Dr. Cassell, because it is in the foreign instance that people at the grassroots level who are fighting for their rights that can find support, because you are fighting not only against a repressive government, but there are elites that support them. And so it's a very not level playing field. And it's the international audience and the international institutions that come and level the playing field. Well, with that, let's go to our coffee break, which now is 10 minutes.